I didn't. The only thing I addressed was that the reason you said he was revoked was because of the 40 emails to his other attorney.
Page 4 and 5, State of Nevada versus Bellisario, C 354165 and C 362447.
Yeah, Andrew Sutton and Mr. Bellisario. I'm handing it for something on a different matter. And this is our motion for in custody status. Brad is present and in custody.
And state?
I'm Baharav for the state.
All right, thank you. And this is defendant's motion for change in custody. So Mr. Flahive, you can go first.
Thank you very much. Now, the state made a long argument, quite frankly, for, hey, this is what bail should be set, and I appreciate it. However, I'm going back to my motion where the statute says before he can be revoked, this is NRS 178.8, excuse me, 0.48517, where yes, the judge can revoke bail, but he has to be given notice ahead of time and he has to have a hearing. It doesn't actually say that he has to have an attorney on the statute. However, at that point, he didn't even have an attorney because when his bail was revoked, or when you revoked a bail, he was in the Young hearing. And at that point, you had said, yes, I believe that this has deteriorated. So he didn't even have an attorney. So I appreciate that the state says, well, he was put on notice because you said there were, you said if there's any more violent emails, I'm going to revoke you. I don't think that qualifies as notice. I mean, if we're talking to a layman, possibly, yes, but there is a reason. Anytime I serve a motion of any type or an affidavit, I have to have official notice. It has to be signed by me. I mean, civil law, criminal law, family law, there is legal notice. He was never given that. He came in for a Young hearing and it was like, hey, sorry, based on behavior, I'm going to yank it from you. Second of all, he didn't really have a hearing on that matter. You could say, hey, he's going to have a hearing today, but that doesn't go back to the statute was ignored. He is a prickly character. I get that. And some of his behavior is, but we still have to follow the rules. Like, and it's funny, this isn't a Supreme Court case, but like all those cases, which are like landmarks, those were also prickly characters where the rules were not followed correctly. And now we all know them by heart, like Gideon versus Wainwright and things like that. We have to afford him his due process. For that reason, he should be let out right now because he's been incarcerated for 7 months improperly, not following the law. He should have, if the state wants to revoke him, the state should serve proper notice on his attorney, which is me at the time, and he should have an attorney for that. As I said, some of the things that he has done since, maybe that is right for revoking his bail or modifying his bail or adding other custody things, but he didn't even get notice or hearing. The state addressed bail. I did not address bail because, quite frankly, I think it's not proper at this point. I think it needs to be released. However, if this court tells me I want you to address bail right now, I will do that, of course. Does that make sense?
Yes.
Thank you.
Anything further?
Unless the court tells me they want me to address her counter motion.
You'll have a chance to reply.
That's what I thought. Thank you. I appreciate you, Ron.
So when looking at the statutory scheme cited by the defense, it indicates that when the state takes an action to remand a person, they obviously have to have their hearing. Unfortunately, when the defense files motions that have to stay proceedings and then attributes that delay in some issue to the court, I think that's inappropriate. As the court can see from the state's argument, we did file a counter motion to address bail because until we got the transcript and were able to review it, we had no idea what behavior had occurred that would have resulted in a change in status. And so once we got the transcript, we did file the counter motion after the defense filed their motion. But in terms of the delay, I want to point the court's attention to the fact that on July 15th, 2024, the defense filed a motion to remove your honor. And that wasn't decided until August 27th. So you've got about a month and a half where the case had to be stayed pending the outcome of that. In addition, on September 19th, 2024, the defense went to competency court to have evaluations done for, I'm not sure exactly why, but my understanding has something to do with the fact that the defendant has been claiming he has mental health issues throughout this case. And so they just wanted to make sure he's on board or is able to understand what's going on. He didn't return until October 8th. So you've got another several weeks where there's some sort of delay here. In addition, now we need the transcript because neither counsel nor I were present for that hearing. He had a different counsel where that behavior was concerning, so much so in front of this court directly that it determined that this defendant was a danger, an immediate danger, and needed to be remanded. And again, I reiterate that the state wasn't even aware of why that happened until we got and reviewed the transcript, which is the basis of this motion now. This defendant is a danger to the court. That's why we filed the counter motion. That's why we filed the motion to remand him in the first place when he picked up the Colombian bow tie case. That's why we filed an opposition and a counter motion in January of 2023 to again address his custody status. And since this defendant is now asking for us to again address his custody status, the state's counter motion is timely. And not only is it timely, but it gave 6 days notice for this defendant to be able to bring information before this court to address the bail. So I think at this point, should it have been addressed sooner? Possibly, but until the stuff is unsealed, the transcripts are unsealed, we can't address it. Should it have been addressed sooner? Maybe, but while you're pending the case as stayed, we can't do anything on this case. So while I submit that there may have been some delay, I think at this point, we can properly address it. He doesn't have to be released unless the court decides that that's appropriate for bail in this instance, which is why we filed that counter motion. And so we're asking the court to deny a release, or if the court's inclined to grant bail, we're asking for $1 million bail. We're asking for high-level electronic monitoring. We're asking for a source hearing for that bail. We're asking for no contact with any of the original victims, but we're also asking for no contact with any former lawyer that happened to be on this case, of which there are legion at this point. He has no reason to go to any of their offices. He has counsel on this case, and if he needs something from them, he can do so through his attorney. Thank you.
Thank you. Okay, Mr. Flahive?
I'm going to address, I don't think I ever alleged that any delay in this matter was based upon any of the state's behavior. And I stick by that. I think when when his bail was revoked, I believe that was done improperly. Again, NRS 178.48517, he must be put on notice. He must have a hearing, which was not done. And without getting too much into any conversation we had, because I'm not allowed to, I have made everyone fully aware that when I did file an affidavit to ask for you to be taken off the case, that if we're asking for you to be off the case, yes, I don't think it's proper for me to file motions in front of you at that point, and the same thing with competency.
Understood.
So I don't think there was a delay by the state. Again, the state wasn't even at the Young hearing, but he was entitled to notice, which he was never given, and he never had a hearing, never had an attorney. Would you like me to address the bail itself? What I think it should be?
Here's where I'm at, and I have a question for you.
Yes.
Do you consider this to be the hearing that he never got? Because you've made all the arguments in your motion that I believe you would make at the hearing that we were talking about that's missing.
I don't believe I did, quite frankly, because I didn't address, hey, what is the least restrictive method to hold him for? I didn't. The only thing I addressed was that the reason you said he was revoked was because of the 40 emails to his other attorney. And then I mentioned that out of all the emails, don't get me wrong, I don't like getting 4 emails from a client, but I have done so through many clients before where I'm getting 40 emails. Most of his emails were inappropriate, and I'll say that, but I don't think any, like, I'm going to go after the bar, I'm going to sue you. I don't think any of them were life-threatening. There was the one which said we need to meet before court, which you could take as like, but I'll tell you this, I talk with my clients all the time. Hey, let's meet up before court. Sure, get there 15 minutes earlier.
So,
but I mean,
the reason I revoked him is because I determined, based on all of the circumstances, his prior behavior with attorneys, his prior behavior, which he was remanded on before with the DA's office, and then on top of all of that, his escalating, and this is in the record, his escalating agitation and inability to control himself in court that I witnessed,
okay.
Culminating with a large number of vulgar, threatening emails. And I specifically told him, just because you didn't physically, because he kept saying, I didn't physically threaten her. What that told me was that he was calculated enough to make sure he didn't physically threaten her, while he said the tone of the emails and the language of the emails and the threats in the emails equaled a threat to the point where he knew to physically not say something, I'm going to hit you or whatever, but the actual tone of all the emails and the things that were said, including the vulgar language, amounted to that, especially combined with his inability to control himself in court, to even stand still, as a matter of fact, not to mention controlling, interrupting the court, interrupting other parties, interrupting his own attorney. Okay, so it wasn't the however many it was, 40 some threatening emails and the vulgar language alone. It was the entire circumstance and his growing inability to control himself even in front of the court that made a determination that he was a danger to the community, okay, at large, including his attorneys. Now, that having been said, I understand your argument is that he didn't get a hearing.
No, he didn't get notice, he didn't get a
Right.
hearing, and he didn't have an attorney during that hearing.
Right.
Two, which are required by the statute, and I'm sure if we look through it, you're entitled to an attorney through any substantial proceeding, not all proceedings, but I believe that that would be considered a substantial hearing, yes.
Okay, so this is not that hearing.
That is not, but since we've addressed bail, if you want me to, if you are inclined to hear the argument, since it appears you do, since you say I addressed many things, I can keep going a little bit, which I would appreciate if you want me to, unless you are inclined to release him and have the state give notice to set bail, then I'll keep my mouth closed so I can address all of the points. with a little
Okay,
more time.
because from the motion that I read that you wrote,
Yes,
it's my perception that they contained arguments that would be made if a hearing had been set, the hearing that you say is missing.
I, that's fine.
Okay, so that, I'm just telling you where how I'm seeing this.
Okay, again, and it's not necessarily a motion for bail, it's a motion for change in custody just to have him released. So that if this court or the state wants to follow the statute properly and serve his notice, his attorney with notice that they want to revoke his bail. I have another case right now where I have a client who went out and committed bad acts and he served the motion, hey, we want to revoke this guy's bail. Even though the client was in jail when he did that, and we have it on court on next week. I mean, there is a proper way to do this. I mean,
Well, that's what I'm saying. Hold on. Is you're saying that at that time, even though I deemed him a danger, he should have been released for that day, not taken into custody, and I should have set a hearing, okay? So he's been in custody and there's been, and the rule is ideally it would be the first available time that he could have a hearing, especially if he's in custody, which he is. So what the state's point is that this is the first available time to have that hearing because of the motion to recuse me and then the subsequent motion for competency. So here we are. And, you know, I'm looking at the argument in your motion and you make all of the points you made today. You even cite some of the transcript of what was said, why he was revoked, whether he's a danger or not, the fact that these were not physically threatening emails. You've made all of that. I don't know what other argument you would make if that day I had said, okay, we're going to have a hearing next week.
well, I'll make the argument right now. I appreciate that the state.
So go ahead.
Well, yeah, again, I'm making this argument because it looks like that this is the time that you are asking for a bail argument to be made. I am still,
What I'm saying is, let me make this clear,
Thank you.
is that I think it's legally absurd for me to say, as we all sit here today, prepared, having tons of notice that this hearing was happening, having you had the opportunity in writing to make and verbally to make any arguments you're going to make that he should not be remanded. Okay. And the state to make their arguments and now also their counter motion for a higher bail and your ability to respond both in writing and here verbally, that I would say, okay, we're now going to release him today and set a hearing in say a week or two to make these exact same arguments. So what I'm saying is this is the hearing.
Okay, you're saying this is hearing, and just for the record, for the last time I'll say this, I still think that NRS 178-48517 should be followed. I still think he should never have been incarcerated without notice, without a hearing, without an attorney. But you're saying this is the hearing now, so a little more to add to the argument. Again, there was no violence, and I appreciate that you're saying there might have been gameplay with the emails that he sent. But even when you ask his previous attorney, you feel threatened? His previous attorney said, I don't feel physically threatened at all, though I do feel threatened when he's going after my bar license and saying he's going to sue me. So no physical violence there. Also, when I was reading through the state's opposition, it was going through a lot of his history and everything. And I believe he was originally charged with a domestic violence. Then they amended it a few times. They added some aggravated stalking and such like that. It was continued a few times, maybe by Bradley's point, but by Bradley's request, but I also noticed the state amended it twice. So I'm assuming that they were copacetic with it being, continued. When it went to the grand jury, they did not bind over the domestic violence. They bound over nothing with actually had actual physical violence. Was there the stalking, which is a B felony? Yes, that's a serious thing. But if you look through all of his history, to my knowledge, he has never been, don't scare people, I get it. But he has never been physically violent to anyone. I know he has threatened people, and there are those letters right now which says, hey, we're going to do this to you, the necktie. He has charges against him. When we look at it, I'm like, wow, I can't believe you sent that. However, Congress has decided that level is a misdemeanor. Okay, it's just a misdemeanor. I know that's what Congress, the people like.
But let me just, and I don't usually like to interrupt. No longer has the presumption of innocence. He has pled guilty to a category B felony in this case.
I appreciate
Okay,
that.
go ahead.
But to my knowledge, that it was not brought up by the state's opposition or by your brief comments.
But I'm just responding to what you just said.
Okay, thank you. But it was a misdemeanor. We still have to look at, well, if we're going to bail, what is the least restrictive way of keeping him behaving himself? High electronic monitoring. If you want to set bail, I get that, but we're asking for millions, pretty much just saying, hey, we know we have to follow the rule, but that's gameplay, just like you were saying, well, he was trying to get around the rule. Well, we want bail, but it's going to be $1 million. 2 cases in the news recently, I love reading, well, I read them online right now. 3 gentlemen allegedly kidnapped some guy, took him to the house, zip tied him, waterboarded him, poured scalding water where the guy got 3rd-degree burns, $100,000 bail. That's 1/10 of what the state is asking for. Another case I just read on the sex team case, there was a coach who was taking back 14-year-old and 15-year-old girls to his house and doing all sorts of bad things. Also $100,000. So $1 million, in my opinion, it's just ridiculous. It's just saying, hey, we're not going to give you bail. If it's $100,000, I don't like that, obviously, but I think that would be more appropriate because assuming his parents help him post it, I believe he is still in a good relationship with his parents. And if you ask me, is there anything I would not want to screw up in my life? It is my relationship with my parents, quite frankly. I just would not want to leave them in the lurch. So that should keep him. Maybe if you also say, hey, you're going to be on high level, we're going to set bail at 100,000. I was thinking about this. It looks like the worst thing he has, and I'm jumping back. Both of his first 2 attorneys, the one which seemed to do serious work on it, like I know he went through a few others, but they were on and off, quite frankly. Both knew he had mental issues. Both were made aware of it. I know he didn't provide further documentation, but when I sent him to competency court, both of them came and said that. It seems like at one point he was also looking for co-occurring. So he might have a drinking problem. I believe you might have said, I think he's got some alcohol problems. I get that. So we would also say no drinking, no drugs, must stay on any medicine. But he's also jumped on his computer. I don't know if he was high at the time or drunk. I don't care, or if he just was off his meds. But yes, sending 40 emails is outrageous. Maybe on his computer, the only people he were allowed to do is email myself, stay in touch with his parents, access to Westlaw and LexisNexis, because I know he wants to do some research on his own cases. So the question is, do we believe that would keep him from committing more crimes? Probably. He's shown up to every appearance. The only thing he has done since are send out outrageous emails and outrageous letters. Since he's not committed any violence, he's not left where he's not supposed to go. So, I don't want to get emails from anybody. But that is not the worst crime of the century where we say, hey, no bail. Thank you, Your Honor.
All right, thank you. And just because I didn't want to interrupt, to clarify the record, his prior attorney was afraid physically, and she wouldn't even stand on the same side of the courtroom as him. So it's part of the record. So I understand that also part of the record is she said he didn't threaten me physically because the emails don't have that in them. So why would she say that? But she was technically still his attorney until I made a decision on the Young hearing. And she asked the marshal if she could stand on the other side of the room because she was afraid of him.
May I have to respond in 30 seconds? I
Okay,
appreciate that, but he had no attorney at the time that he was revoked. That's correct by the record. You had removed his.
oh yeah,
previous
no, I'm not
attorney.
saying that. I'm just
Okay.
saying, I'm just correcting that you saying that she said she wasn't afraid. She was afraid.
I am just looking for a very clear record in case
Right.
later he needs to do after trial remedies.
Me as well. Thank you.
Thank you, Your Honor.
Thank you. Well, I'm not sure that a game is afoot when I very clearly indicate exactly what I'm asking for, which is a bail such that this defendant is going to be detained. I originally asked that this court hold him no bail. The court denied that request. In January of 2023, I again asked this court to hold him no bail. The court again denied that request. And since January of 2023, there has obviously been an escalation of conduct which requires this court to prevent any further damage to any members of our community and hold him no bail. But listen, if you need to set bail, I am in fact asking for a bail amount that it will be tantamount to a detention. That's pretty clear when I ask for $1 million bail. We did try the least restrictive means. This court 2 times allowed this defendant to remain out of custody on house arrest, despite the fact that it could have held him no bail when he picked up the next aggravated stalking case. You gave him that choice. You allowed him to have house arrest. You allowed him to continue with his treatment. You allowed him to have alcohol monitoring. You allowed him the least restrictive means necessary over the objection of the state. And it was before this court that he demonstrated that those least restrictive means were no longer going to work. So that's why I'm asking for that bail. That's what I'm asking for, no bail, but that's why I'm asking for bail if you're going to set bail. And that's also why I'm asking for those additional conditions. And the other thing too, in terms of the domestic violence, as this court's aware, we can't indict misdemeanors. The grand jury does not have jurisdiction over misdemeanors because they can't go to district court. So that the misdemeanor domestic violence, which was dismissed, I think in 2020, yeah, we can't indict that. And at this point as well, it's well time barred. But what is still pending in justice court is the part of this case, the partner to this case, which is the violation of the domestic violence protection orders that were also part of the aggravated stalking. So there are still 2 cases in justice court, one of which does involve violating domestic violence protection orders. The next one's that theft that occurred around this time, which of course I'm not trying to argue in any way violates any of the conditions of this. It just got filed a little later based upon some delay in getting some information. So I think that we have complied with the law. I have made that pretty clear in our motion. In addition, we have filed a counter motion to address bail. We are asking you to hold him no bail. We have asked you to hold him no bail 2 previous times. If you're inclined to set bail, then I'm asking for bail that will be tantamount to detention. Thank you.
Okay, and it's your motion, so you can speak
I think
last.
you already gave me a chance to reply.
Okay, here is my concern, and the state correctly stated that, you know, we've been here a few times with them requesting to revoke bail. And it was my decision a couple of years ago to do the scram, which seemed to be working for quite a while. But then it stopped, and that is my concern. That is my concern and why I went ahead and put him into custody last time. So what I'm going to say to your motion today is, assuming that your motion is correct, okay, and that he should have had a more formal hearing, it's granted, but today we had the hearing, okay? So everything was said, everything was briefed, everything was argued. And I've noticed Mr. Bellisario is doing much better today. And we're right back to where I was originally. When he is under strict, very strict supervision and care, like when he's in custody, he does better. For whatever reason, even with scram, and it may have this time not been drinking, this time it may have been just that he wasn't taking his medication. He escalates to a lack of self-control. And so far, it has been shown in threatening emails. And so we're talking about the case that's in justice court right now. Then now we're threatening emails, but he's crafty enough to make sure he doesn't threaten anything physically, but the tone, the number, as I've already gone through, the vulgarness of the emails was clearly physically threatening. And it did its job because his attorney was physically afraid of him. And so based on that, I am not granting bail. He needs to stay in custody until sentencing because one, I think number one, it keeps the community safe. But number two, I think it's what's best for him because he is now filing a motion to withdraw his plea. And honestly, the last thing he needs is to either go off his medication or start drinking again and shoot himself in the foot. So you are better off in custody and the community is safe from you in custody because I do not trust that you will not start escalating again. And history has shown in other cases that this type of behavior sometimes doesn't amount to anything but more threatening emails, and sometimes somebody gets shot. So based on the long record of you losing self-control when you're out of custody, this court is not willing to take the chance that it's going to end up in the latter. So you will remain in custody without bail.
Yeah, I just want to point out that, as he said, as he argued, I had no notice, no attorney, no hearing, right?
Right.
So you violated my constitutional rights. Now, putting the hearing after the fact is, in my opinion, fraud on, is you're making a different standard. Now I have to argue to get out versus them arguing to put me in. Right?
I understand
I'm
that.
saying it's, and
They
it's
also fired a counter motion to put you in.
fine.
And the standard didn't change.
I'd say it's a piece of discretion in the first place. You should not be on my case. It's manifest error, failing to avoid an unambiguous safeguard provided by the statute. It provides a fundamentally unfair result. I don't know how you don't recuse yourself in this case. Like, it's,
All right, I'm not going to hear anymore. You've already had your motion to recuse me and it was denied, so I'm not going to hear anymore. All right, so the hearing's over. We're done. That's my order. Thank you.
I have no chance to even talk to you.
You have an attorney. He spoke for you.